Hello everyone and welcome to episode 3 of the World of Employment Law. So I'm Gemma Clark, I'm a solicitor in the employment team and I'm joined today by my colleague Sophie, who's an associate in the team. So she's going to introduce herself.
Hello everyone. So this is actually my first podcast that I'm doing, so I'm really excited to be here. So I'll be talking alongside Gemma about the various changes that are upcoming in April. Well, most of them will be in April. Some of them are earlier in the year, and actually one of them I'm covering isn't going to be till next year, but it is an interesting one, so we thought we'd cover it today. So just to summarise briefly what each of us will be talking about, so you know what's to come in this podcast. Gem, I'll hand back to you to summarise.
So I'm going to talk firstly about a couple of changes that came about on the 1st of January 2024. So hopefully you've already seen those out and about, but if not, it'll be a good recap and overview of those. And they've come about as a result of Brexit, that dreaded word, and what EU law we're looking to retain in the UK. Then I'm going to look at talking about the flexible working changes, and hopefully you've all heard about that. It's been a long talked about change. And then finally, I'm going to talk as well about the potential extension of protection from harassment in the workplace.
And the topics I am going to cover, funnily enough, I've actually shortly just returned from maternity leave. And a lot of the topics I'm talking about are related to family leave. So the first thing I'm going to discuss will be the amendments to taking paternity leave, how much can be taken and when that can be taken. I'll also be talking about the extension of protection from redundancy for individuals on certain types of family leave. And I'll also cover some considerations for employers for once those changes come into place. I will be touching on some leave regarding carers and also some leave regarding parents of poorly babies after they're born and what their rights will be. So some interesting topics to be discussed today.
So starting first with changes that have already come into effect. So looking back at last year, there was a government consultation in May 2023 in respect of key areas of retained EU employment law, which it was felt could be benefited from reform and better tailored to the needs of the UK. So within that consultation, there was discussion about record keeping and requirements under the working time regulations, potential simplification of annual leave and holiday pay calculations, because that's a very complex topic and there's been a lot of talk about that in the last couple of years. And also the consultation requirements under the Transfer of Undertakings Protection of Employment Regulations 2006, commonly called the TUPE regulations. Now, the government gave their responses to that consultation in November 2023, specifically the 8th of November. And during that, they also took the opportunity to respond to an earlier consultation that happened in January 2023 regarding calculation of annual leave entitlement for workers with irregular hours or part-year workers. And this came about following a big Supreme Court decision, Harper Trust v Brazel in July 2022, which changed guidance on holiday pay for those individuals and had implications as a result of that. And therefore, there was a consultation launched to see if we could clear it up a little bit for everyone in the workplace. So what came about as a result of the consultation? In fact, there was some legislation introduced on the 1st of January 2024. So the key things to know about that are, happily, it simplified holiday pay calculations. So what it now does is it permits rolled up holiday pay. So that is now lawful when previously it wasn't for part-year workers and those workers with irregular hours. And that's using the standard calculation of 12.0% of pay. So hopefully that makes holiday calculations a little bit easier in the workplace for everyone. There was also about working time records. So there was no longer a requirement for employers to keep records of all working and rest time. So again, hopefully that makes it a little bit easier with the recordings in the workplace. And finally, there was also increased flexibility with consultation during a TUPE transfer. So this widened the ability for employers to consult directly with employees during a TUPE transfer without the need to appoint employee representatives or trade union representatives if one's recognised. So now businesses that have fewer than 50 employees in total, or any size business that has less than 10 employees transferring under the TUPE regulations, can directly consult with their employees if they wish to do so. There is a provision to that, however, that if employee representatives or trade union representatives are already in place, then they would have to be consulted with. So that was some of the updates. There was another one specifically in January 2024, which was about the Equality Act 2010 Amendment Regulations 2023. So they looked to modify the Equality Act 2010 and essentially protect against discrimination, which otherwise some of the laws would have ceased to apply following Brexit. So the idea is to strengthen the protection in relation to discrimination in the workplace in a number of ways. So I'll just talk about a couple. So the legal definition of disability has been extended under the regulations, and there's additional protection given in employment for employees returning from maternity leave in respect of certain types of unfavourable treatment. So there are a lot more changes that brought about, but there's just a couple to give you a flavour of that. So now I'll pass on to Sophie, who's going to talk about, I think, a change coming up in March.
Yes, so this is regarding paternity leave. So that's the leave that the partner of the mother can take. So whether it be the father or just the partner of the mother. So at the moment, they are entitled to take 2 weeks of leave after the birth of the child. It has to be taken currently in one block of leave. And the partner or father must notify their employer at least 15 weeks before the week on which the child is due to be born. And they must notify them of the date on which they intend to take their leave. Now, the paternity leave amendment regulations coming into force on the 8th of March, and it's relaxing this slightly and changing the rules. So the entitlement is still, unfortunately, only 2 weeks, but the changes that are coming into force is that the paternity leave can be taken in 2 one-week blocks rather than 2 consecutive weeks. So if the individual wanted to take paternity leave for a week straight after the child is born, they can. And if they want to take another week when their child is 10 months old or 9 months old or on their first birthday, that is fine. It has to be within the first 52 weeks after the child is born, so that's important to remember. Additionally, the notice period has been reduced. So I just mentioned that it has to be 15 weeks before the week on which the child is expected to be born. That's now been reduced to 4 weeks. So as long as the individual notifies their employer within that 4-week period, then they'll be able to benefit from these new regulations. So why have these changes been brought into force? Well, firstly, it's to enable people to have greater flexibility over the leave they want to take when their child has been born. And the part of the purpose is said to be able to give the person more control over the time they want to spend bonding with their child. So someone might decide that they don't want to take their leave immediately after the child's born and they would rather wait a few weeks or wait a few months. It's just to give them more flexibility and more control over that. There has been criticism of this. Some people are saying it still isn't enough, that we have the most rigid family leave rights in Europe and that more needs to be done. Many people are saying that fathers and partners of the mother need to be given far more leave. For example, in Sweden, I think it's 90 days leave they get. And so there is a lot of push for the UK to match this, but at least it's a step in the right direction. So that's paternity leave covered in a nutshell. And like I say, 8th of March is when the changes are going to come into force.
So as we said at the beginning of this podcast, there's a lot of changes looking to come in April 2024. The new tax year, often there are lots of changes in employment law, so it's always good to be wary around that time. So the first one I'm going to talk about is the Flexible Working Amendment Regulations 2023, which look into the employment right of flexible working and the right to make flexible working requests. Now, this has been in discussion for a long time, and there are a number of changes that are looking to be made in respect of this right, again, to provide employees greater flexibility in the workplace. It could be about their hours of work, what days they work, where they work, if they want to do compressed hours or a job share. There are lots of different types of flexibility in terms of work for employees. And the idea behind the amendments is to support employees and workers have that greater flexibility in the workplace. So what are the changes that are looking to be made? So following a statutory instrument in December 2023, the key right that a lot of people have been talking about is that now employees and workers will be able to make a flexible working request from day one of their employment. Currently, you have to have 26 weeks of continuous service to be able to make a flexible working request. So that's getting scrapped. And from day one that you start with any employer, you'll be able to make the request. So it'll be interesting to see how that develops and how many requests come about in that first 26-week period that previously wasn't permitted. And there are some other requests as well. Now, again, they're looking to be brought in potentially around the same time of 6th of April 2024, but there's not actually confirmation yet as to when they'll be brought in. But it's thought that they will align with the change to the day one right. So what are these changes? The first one is that employees will be able to make 2 flexible working requests within a 12-month period. Currently, there's only 1 allowed. So again, the idea behind this change is to give employees a bit more flexibility because 12 months is quite a long time for them to wait, potentially, if they want to request a formal change to their contractual terms. Another one of the changes is that the decision period for employers, now that's currently 3 months. So once they've received a flexible working request, they have 3 months to consider it, decide whether that would be reasonable, whether one of the 8 reasons for refusal does apply, and if it doesn't, then it would get accepted. But there's a 3-month period for them to make that decision and confirm it to the employee. That's getting reduced to 2 months. So the idea is to try and deal with flexible working requests more quickly and hopefully let employees who want to make those requests and have that change get that implemented a bit more quickly. Another one of the changes is currently employees have to let their employer know when they make flexible working request what they think the impact could be on the business as a result of that request. So that, again, is being removed. So employees no longer need to predict that, essentially, as a result of making their request. And finally, the other amendment is looking at to say that employers, before they refuse a flexible working request, now they can only do that in limited reasons. As I mentioned, there are 8 reasons under legislation. But if they were going to look to refuse a request on one of those reasons, they would have to first consult with the employee and meet with them. They can't just refuse it without any consultation about that. So again, the idea of that is hopefully to try and see if a compromise can be reached between employer and employee as to whether there is a different request that could be agreed that fits for both of them and works for both the company and the employee, and have a bit more discussion so everyone knows what's going forward and what's the plan is. So those are the changes coming in, most of them hopefully in April, but we'll see how it goes. And I think there are some other changes that Sophie's going to talk about in April as well.
Yes, thanks, Gem. So back to me. Another change that is due to come into force on the 6th of April this year is regarding protection from redundancy. So at the moment, employees who are on either maternity leave, adoption leave or shared parental leave, so it's not just women, that could be fathers who are sharing their partner's maternity leave, are entitled to first access to suitable alternative employment in redundancy situations. Now, from April this year, this is going to be quite significantly extended, and this is really, really, really important that employers are aware of this. So the protection is going to be extended as follows. Any employee who is on what we call a protected period of pregnancy, and I will cover what that is likely to mean in a moment. Any employee who's recently suffered a miscarriage, or any employee who has recently returned from maternity leave, adoption leave or shared parental leave will also be entitled to enhanced protection from redundancy. Now, what does that enhanced protection mean? Essentially, what it's going to mean is that they will get first access to suitable alternative employment in a redundancy situation. As part of the redundancy process, employers are legally obliged to look at suitable alternative roles for employees at risk of redundancy before making them redundant. And so anyone who falls into the brackets of the list I just went through will also be given extended protection. Now, the extent of the protection is still yet to be covered, so we need to wait and see how long that's going to last. But I mentioned a protected period of pregnancy. From the consultation, it's likely that this is going to be the period from which the woman notifies their employer that they are pregnant. And how long is the period of protection likely to last after someone comes back to work? Again, from the consultation, it seems like it's going to be approximately 6 months, but we need to await further clarification on that. So that's just covered how the protection is going to be extended. Now, what are some practical considerations for employers? There's quite a few, and I'm just going to cover them now. So, firstly, actually, an employee could benefit from up to 2 years of extended protection. So if we think about the fact that they might tell their employer when they're 12 weeks pregnant, they might then take 52 weeks of maternity leave, and they might then be protected for a further 6 months. If you would do the maths, that is 2 years of extended protection, which is quite a lot. So employers need to be aware that this could, protection could last for quite a long time. As statutory shared parental leave could be available for either parent, employers cannot just think this only applies to the mothers because we're talking about maternity leave and adoption leave. It can very much apply to men in the workforce as well. So employers might see a big increase in men acquiring enhanced protection rights against redundancy. So please be aware of that if you're an employer. It doesn't just apply to women. We are still awaiting clarification on the ramifications of an employer's failure to offer a protected employee a suitable alternative vacancy, but we can expect to see these being similar to those that are currently available to employees, i.e. automatic unfair dismissal and discrimination. So if you fail to follow the correct process when the regulations come into force, the ramifications could be quite serious. So please make sure you're aware of them, and more importantly, take that really important legal advice before you embark on the process. Employers will need to work really hard on ensuring that they accurately identify suitable alternative roles. Now, we know this can be quite a boring exercise. We know it can take a long time. We know it can be quite paperwork heavy, but it's absolutely fundamental that now this protection is being enhanced, that employers really sit down and look at what a suitable alternative role is going to be for those women who are pregnant, who are on maternity leave, and all those individuals who have taken shared parental leave or who are in that protected period after they've returned to work. And I think that's probably the majority of the practical considerations that I wanted to cover today. I could go on forever. I won't. I'll stop there, and I will hand back to Gem, who I think has one more to cover.
Yeah, so looking forward a few months into October of this year, the Worker Protection Amendment of Equality Act 2010-2023. So what is this all about? The purpose of this legislation is to make the workplace a safer environment to workers. So it's looking at extending the protection for workers of harassment in the workplace. So what it does is places a positive duty on employers to take reasonable steps to protect their employees against sexual harassment in the workplace. Now, when this was going through the parliamentary requirements to get royal assent, there was discussion, and originally there was the word all reasonable steps included, but that was taken out as it was felt potentially a bit too much of a positive duty to place on employers. But it does still say take reasonable steps. So there is a duty on employers there, and they need to have that as a consideration and understand what potential responsibilities they have, because if they are found to have breached this duty, then employment tribunals will have the power to increase compensation in employment tribunals by up to 25%. So that's quite a hefty increase that they might face for not having complied with the duty. So it's important to get ahead and look at and see what you can do within your workplace to help take those reasonable steps to protect against sexual harassment. So that probably covers the ones for this year.
My mistake, I missed one out. I have one in April 2024. Right, so this is just the short one, but another step in the right direction, again, relating to family leave. So this is another one that's actually going to come in on the 6th of April 2024, and this is the last of the changes for that date. So employees who are carers for dependents with defined long-term care needs will now be entitled to take 1 week's unpaid leave per year. Now, this is going to be what we call a day one right. So there's no minimum length of service. Employees will be entitled to take this leave from the first day of their employment. They can either take it as a block or as individual days within a 12-month period. Now, there are minimum notice periods that need to be adhered to, and which I think we're just awaiting some clarification on that. But although employers cannot decline a request for leave, they can postpone it within certain parameters. So if it's not going to work for the business, they can have a conversation with the employee and say, look, is there any chance you can take the leave on this date instead? But employers are strongly considered to really, strongly advised to consider whether they really do have strong grounds to decline a request. So what are long-term needs? So those are defined as anyone with a condition that meets the definition of a disability under the Equality Act. So that's a physical or mental impairment which has a long-term adverse effect on someone's ability to carry out day-to-day activities, long-term being 12 months or more. An illness or injury, and that can be either physical or mental, that's likely to require care for more than 3 months, or anyone who is elderly, essentially. So if you have a dependent who falls into any of those brackets, then you will be entitled to take 1 week per year of unpaid leave to look after them. So the final update that I'm going to cover is the Neonatal Care Leave and Payout 2023. So this isn't actually due to come into force until April 2025, but I wanted to cover it nonetheless. It's another step in the right direction for family-related leave. So what this act is going to do is it will give parents of newborn babies who are sadly going to be hospitalised for 7 days or more in the first 28 days of their life the right to take neonatal leave for up to 12 weeks. So what this new legislation is intending to do is just to enable parents who have poorly babies in hospital the ability to spend more time with their babies who are having crucial care in hospital without worrying about taking unpaid leave from work or, worrying about taking extra time off work. It's now going to be a legal right of theirs to take that time off to spend with their unwell child. So parents who take neonatal leave are also entitled to return to the same job after that period of absence, so they can rest assured that they won't be going back to less favourable treatment or changes to their terms and conditions or changes to their working environment. They can expect to come back to the same job after taking that crucial time off to spend with their child. So lots of positive changes coming into force, lots of steps in the right direction. I think we all acknowledge that there's more that can be done, especially in relation to family leave, but it's really positive to see that there is such acknowledgement in relation to all these legal updates that are coming into force.
Yeah, and there are likely to be many more updates that either come into force this year, if they can get passed through relatively quickly, or in the coming years. But it's important just to stay up to date and aware of potential changes. And if you ever do want any advice as to the changes coming into force, please do get in touch with the team. And thank you for listening to our podcast.
Thank you very much, and we'll see you next time.